Okay, EmRôs signing in. I want to make this video about a security agreements. Something I learned about a security agreement that I did not know back in 2019 when I had my old YouTube channel, and which is the reason why I didn't fool with the UCC in the first place, because it didn't add up. Okay, people used to send me all types of stuff. The more information I shared, the more information people share with me. So, one bit of information that didn't add up with me that someone sent to me was a template of a security agreement, and that security agreement was where the straw man was doing was in agreement with the living man, where the living man they're doing a contract together. Even as a damn amateur, the shit didn't add up to me. It didn't sound right. Okay? Because I'm like, if the living man does not exist in the commercial world, how can I contract with a fiction, with a fictitious entity, an artificial person? How can a natural person contract with, like, in a written contract with the straw man? Especially if I got to sign on behalf, that's an agreement. I got to sign on behalf of that straw man. Michael Roseman signing on behalf of the straw man, and Michael Roseman also signed on behalf of the natural person, Michael Roseman. This shit didn't add up. That's why I didn't fuck with the UCC for years until last year. Okay, that's when I had to revisit it, because I didn't bother. I kind of put it on the back burner, so I didn't really look into it that much. I was just kind of concentrating on other stuff. So now that I have come back to revisit this stuff, y'all know I have to take my break because my body has taken a lot of damage, tremendous damage, dealing with the taking of my son, who's now 6 years old now, and now I'm revisiting this situation. Still studying, of course, but I have a clearer understanding and a clear mind. I'm grounded in my conscience, in my spirit, and in my well-being. Body, coming along. I'm much stronger. You can't even tell I done been through some shit if you see me. But I had to revisit this security agreement, and now that I'm touching on trust law, and I'm reading up on trust law, learning more about it. I clearly understand it. I have created my trust. It is now, the certificate of trust is now recorded in the county recorder's office. I have filed a UCC-1 financing statement, and I made my trust the secure party over the straw man. I'm saying straw man for people who are beginners, who don't know that the Cesta KV trust is the straw man's. One and the same. For you who are just starting, the Cesta KV trust is the straw man. Okay, it's the same thing. I say straw man because most of you are just learning, and y'all at the beginning stages, and some people use Cesta KV and those types of Latin terms. You don't realize that they're talking about the same thing. That is the same name that is in all capitalized letters. On your birth certificate, it's on your social security card, it's on your driver's license, on your bills, your light bill, your gas bill, your mortgage, everything you do business with, they're spelled exactly like your name that your father and mother gave you. Only difference is it's in all capitalized letters. And now some companies get slick and they want to put your name in its proper form, upper lowercase, but it's still the damn name. Okay. They're still referring to the trust, the all caps name, the social, the straw man, the Cesta KV trust. It's still your estate. Everything is all connected to your estate. Okay. So, and your job is to take control of that. Okay. When people tell you to do a UCC, they tell you you have to have you actually have to, if you read, you learn that you have to have a security agreement when you file a UCC-1 financing statement. I'm gonna pause this video so I can go to that real quick. Okay, I think this is a pretty good read right here on Nolo, right here, Nolo.com. If you type this title right here in your Google search, you'll find this article. Just read it. But I'm gonna read it right here on this video. Okay, I would leave the link in there, but that's a little too much work for me, and I don't feel like doing all that. Just type it in your Google search, y'all. Stop being lazy. Just put it in your Google search and find it and read it. Okay. Okay. A security transaction is a loan or purchase that is secured by collateral. It involves a borrower or buyer, technically known as a debtor, and a lender or seller, technically known as a collector, a creditor. Sorry about that. A creditor, and more specifically known as secured party. Commonly secured transactions include a bank loaning a business money so the business can buy inventory, or a company selling a business equipment on credit. In these transactions, the business what the hell is this? Okay, I'm sorry, I got distracted by a damn pop-up. In this transaction, the business is the debtor, the bank or the selling company is the creditor, and most likely the inventory or equipment will be at least part of the collateral. Now I'm going to scroll up. Let's see. Under Article 9, this is the part I really wanted to read. I should have started here. Under Article 9 of the Uniform Commercial Code (UCC), which covers secure transactions, in order for a creditor to become a secured party, that is, a party with a legal right to take possession of collateral in the event of a debtor's failure to pay, the creditor must take special steps. These steps are known as attachments of the security interest. Moreover, in order for a secured party to more fully ensure its legal rights in the event that other parties are asserting an interest in the same piece of collateral, the secured party must take additional steps. These additional steps are known as perfecting a security interest. Here we'll look at both attachment and perfection of security interest. Attachment. A creditor has a secured interest in collateral and becomes a secured party if and when the security interest attaches. And it says under the UCC, the security interest generally does not attach unless three basic requirements are met. In the simplest form, the requirements are that, number one, value be given for the security interest. 2, the debtor has rights to the collateral, or power to transfer the collateral to the secured party, and the debtor authenticates a security agreement. Let's briefly look at each of these requirements. Value. Now, see, people don't get we get caught up on the word authenticate. That's going to be another video. Matter of fact, let me go on down there. Let me see. Let me go on down there and see if it's talking about agreement. I mean, do I want to talk about that right now? No, I think I'll pause. God damn it. Okay, I thought I messed up. Okay, here we go. Value. Secured transaction is the contract between the debtors and securities and the secured party. Like most contracts, there must be an exchange of consideration between the parties. In other words, there must be an exchange of value. Say in the case of secured transaction, the value given by the secured party is usually obvious. For example, a bank gives value to the debtor when, in conjunction with a security agreement, it loans money to the debtor to buy inventory. Similarly, a seller gives value to the debtor when, in conjunction with a security agreement, it sells equipment to the debtor. I want to go through this whole thing because we're talking about the topic of this video is really about a secured a security agreement. But I'm really going through the whole UCC now since I jumped on this thing and read that much. So I might as well go on through it. Shit, if I got to make 3 parts and kind of put it together, that's what I'll do. But I want to make sure this is kind of thorough. So you understand about a security agreement. And what basically you understand about filing the UCC-1 financing statement as well. Okay. Now here we go. What we got here? Let me see. When it comes to, I use CUSIF numbers as well. I even find out about your CUSIF number to your birth certificate or any something like that. You want to get a CUSIF number for your birth certificate. That's what I like to do. That's what I did anyway. You can get a broker to do that. Somebody that's a broker, you could pay them to find out, or you can find out on your own through fidelity.com. Get you an account or whatever. You can do it without an account. So I've been told. I paid a broker to do mine. So, but anyway, let's see. When it comes to attachment, let's see what else I got to do. What else I want to touch on? The debtor's rights to collateral. As a matter of fact, let's look at what a debtor is. I want to pause it because it keeps mentioning a debtor. So we're going to understand who the debtor is. Okay, so I'm going to pause this video. Hold on a second. Okay, a debtor right here. This is Bouvier's Law Dictionary right here. One who owes an obligation to another, especially an obligation to pay money. Okay, in bankruptcy. Okay, I want to scroll up. Let me see if I can make this. Here we go. I'm trying to make it smaller so y'all can see that. I had to do it like this with my damn fingers. I'm doing this video with my cell phone, so y'all work with me. Okay, secure transactions, number 3 right here. That's the definition we're looking for. A person who either has, hold on, I'm gonna pause this, hold up. Okay, here we go. I had to zoom in and kind of screenshot a little bit. It says secure transaction. This is the definition we're looking for a debtor. A person who either has a property interest. See, that's number 1. That's the straw man. We already know that. Anything that's in your straw man's name, you have a secured interest in it. Okay, a person who either one has a property interest, other than the secure interest or other liens in collateral, even if the person is not an obligor. Even if you don't owe a debt, you still got a property interest. If you got anything with your name on it, whether any bills or any type of contract you sign on behalf of that straw man, you have a property interest in it. Okay, whether it's proceeds, whether it's tangible or intangible, it doesn't matter. You have that straw man has a property interest. Okay, that's what it is. Okay, number 2, a seller accounts. A seller is a seller of accounts, chattel paper, payment intangibles, or promissory notes. UCC 9-102. SCA 28. This is basically going to repeat that. If you go to that if you put that in your Google search, UCC subsection 9-102 A28, you'll see this exact same definition. I've already done it, but I'll show you just in case you don't get it. Hold on a second. Here we go. As you can see right there, that's the definitions. Okay, scroll all the way down. Oh yeah, here we go. Just to prove it, y'all can always type this in your Google search and see it on your own. But I'm trying to see. Here we go. That's the definition. As you can see, it's the same exact definition. Okay. The straw man is a debtor. Okay. Straw man is a debtor. Now I've seen people do their own security agreements, and they'll create their own value. They make up their own number as a value given. So that's totally up to you. I found out the CUSIF number. I use it fidelity.com, where I went through my Connect really to find out the value of my birth certificate, my certificate of live birth, through a broker. Okay. And I put that in my UCC. I use that as the actual value of my certificate of live birth. Now, the debtor right here say debtor has rights. The debtor does have rights. The straw man does have rights. And that's why, but you as a natural person, you have rights to that straw man. You're the one that's authorized to use it. So it's you that's actually doing the work on behalf of the straw man in the living world, in the living world. Now, bullet point number 3 right here. Say the debtor authenticates the security agreement. That simply means to sign it, okay? Let me prove that to you. As you can see, I'm on Cornell Law School website. We use that all the damn time. As you see at the top right says a Uniform Commercial Code. Definitions. I'm going to scroll all the way down here to authenticate. Authenticate means to sign. Number A, that's A right there. Or with present intent to adopt or accept a record, to attach or to logically associate with the record an electronic sound, symbol, or process. Okay, that's what it means to authenticate. We try to go so much deeper into authentication to mean something different than what it actually means. Okay, that's all it means. So you see that for yourself. That's what it means, how to authenticate. Now we're back to it. So now we get that we have to sign it. The debtor, you're going to be signing on behalf of the straw man. Okay? But you got to be careful about, not careful. I don't want to use be careful. People use be careful all the time. Have you got them scared to do any damn thing? But you're going to be mindful about how you sign your documents. Okay? If you're signing on behalf of the straw man, you're going to sign it as the authorized representative or the beneficiary. However you want to do it. But make sure you get used to doing those types of things, okay? Because you're going to be operating as a trustee when you're operating from the trust. Because you're going to make, yourself, if you make yourself the trustee, you're going to make sure you sign as the trustee. You sign a document and, your autograph. I'm going to say autograph because they can say, you can say sign, but in the living man world, you're talking about autographing. And you're going to autograph your name and then put a comma after that. And you're going to put your surname first, meaning your first name, your given name, which is your first and middle name. That's going to be after your family name. Okay, your surname is your family name. Okay, last name, comma, first, middle, and then you sign it as a trustee. Or if you sign it as a straw man, you want to sign as the beneficiary. However you choose to do it, but be mindful about how you understand who you are in relation to that name. Okay. You're signing as, so if you're signing as the trust. Anyway, I don't want to go off on a tangent about the word authenticate. Authenticate means to sign the security agreement. So I'm learning that the trust, you creating a living trust. Your trust and the security agreement are the same. Your trust is a security agreement because I'm describing it exactly like they're saying at UCC. What they call a financing statement is supposed to be done. Okay, now we got to about the value, the collateral. Let's see. Let's read up on the collateral. I think I read this already. The equipment to the I think I read the value. Okay, now we're going to read. Get your ass out the way. These damn pop-ups. Okay, debtor's rights and collateral. Okay, a business may have rights in collateral either by owning the collateral prior to the secured transaction or by purchasing the collateral as part of secure transaction. When a business already owns a certain property, it should be clear. It should be clear that the business has rights to the property and can use it as collateral. In other cases, a business will buy items, materials, inventory, machinery, and so on credit and want to use those items as collateral. In such cases, the business will sign a conditional sales contract, which is also considered a security agreement. Also, keep in mind, it says also. There's more than one type of security agreement in which, under UCC sale rules, will give the business the necessary rights to purchase the purchased items to use as collateral. Note, the alternative option of having the power to transfer the collateral often involves relatively unusual circumstances and is not covered here. Okay. Now, But I want to touch on when it comes to the debtor. Keep in mind we're talking about the straw man when I'm talking about the debtor. For this purposes, they just using examples in this right here. But here, your straw man or your ens legis, or we're gonna say your Sesta KV trust, your all caps name, have rights in, say, if you putting anything, whether it's your house, your cars, your whatever, whatever type of property you want to put inside that's on your name, that's on the name of in the name of the straw man. Anything that straw man's name is written on, you have rights to it. You have an interest in it. You have a property interest in it, and you can actually do a UCC financing statement on it. Okay, so you can let your imagination run wild with that. You already know what your name, what that name is in. Okay, what's in that name. So here we go there. So you have rights in it. So if you have rights in it, it can be filed in the UCC financing statement. Now, security agreement. This is why I originally started this video in the first place. For purposes of attachment, the debtor must authenticate the security agreement. In other words, the debtor must sign the agreement. As we already looked at the definition of the word authenticate. Okay, that's why they have it in quotation marks. Anyway, this UCC uses the term authenticate to include the possibility of electronic signatures. Okay, yeah, you can file a UCC online. I did mine online, so I didn't actually put the ink to a piece of paper. I actually did it online. Okay, and they had me to do initials. Type my initials in there to file it. So anyway, it's still done and it's filed. A security agreement normally will contain a clear statement that the debtor is granting the secured party a security interest in specific goods. The agreement also must provide a description of the collateral. See, you got that in your Schedule A, in your trust agreement. In your trust, you have a Schedule A that's part of your trust, where you are identifying the collateral, the property that you're granting, that your straw man is granting to your trust. So that's why I'm showing you that a security agreement, a trust is also a security agreement. Okay, so we're looking at the same exact description that they're saying here. Okay, so let's keep going. Let's see, interest in the goods. I think I said that. I think I read this. A security agreement normally will contain a clear statement that the debtor that's the straw man, is granting. Keep in mind, when I say debtor, think about the straw man, is granting the secured party a secured interest in specific goods. Okay, the agreement must also must provide a description of the collateral. Section 9-108 of the UCC indicates generally that the description of the collateral is sufficient if it reasonably identifies what is described. The same section then goes on to provide a half dozen different possibilities and reasonable identifications, such as specific listing listing a category or a quantity. While the description of collateral in a security agreement may not need to be finely detailed, the UCC prohibits description of collateral that are super generic, such as the debtor's assets, all the debtor's assets, or all the debtor's personal property. Yeah, you got to be more specific than that, okay? Because he can own something even after this thing has been created. Once it's been executed, he can own something after that. We don't want to turn around and try to use this for something that the debtor might have obtained way after this thing the trust was actually executed. So that makes sense right there. Okay, let me see. Let me move. I guess I'll read these two anyway. I don't need me half-assing it. Okay. UCC recognizes that some security agreements are quite complex and therefore has various special rules regarding certain possible agreement terms. To take just one example, a security agreement may include a clause that the collateral is to include property that the debtor acquires after the agreement is signed. See, that's what I was just saying right there. Say, for the most part, the UCC allows parties to use after acquired property as collateral. However, the UCC does not allow after acquired consumer goods to serve as collateral. See, that's why you got to go do a UCC-3 to add collateral, something like that. That's what that's for. You want to add some collateral. But anyway, that's another video for another time. The three requirements of given value, debtor's rights, and collateral, and an authenticated security agreement apply to the most common types of collateral, collateral such as equipment, inventory, and even payments due under a contract. However, for certain less common types of collateral, the requirements relating to an authenticated security agreement may vary. Perfection. Here we go. A secured party perfects. Now I'm thinking about a secured party. The secured party would be your trust. Okay. Secured party would be, that's if you're taking your straw man and you're putting everything into your own private trust. Your own trust that you created, you named, and you putting all the property inside it. That's what makes your trust the secured party. So, but you can make whatever your secure party. I'm just using my imagination because I made my trust my secure party. Okay, so don't be stuck on your trust being the secure party if that's not what you're doing. If you just use your imagination and understand what we're doing. Okay, what I'm teaching here. Okay, a secure party perfects a security interest in order to help assure that no other party, such as another creditor or bankruptcy trustee, will be able to claim the same collateral in the event that the debtor becomes insolvent. By perfecting its security interest, a secured party seeks to gain priority over the parties regarding the collateral. Okay. The precise details of how to perfect a security interest depend in part on the local jurisdiction where the collateral is located. However, generally speaking, the primary ways for a secured party to perfect the security interest are, what the fuck? Oh, I got confused for a hot second. Okay. Y'all pardon me, I've been sipping. Anyway, bullet point 1, by filing a financing statement with the appropriate public office. Bullet point 2, by possessing the collateral. 3, by controlling the collateral, or it's done automatically upon attachment of the security interest. That's when you're filing that thing. Okay, if these four listed items, the first filing of a financing statement is by far the most common and important to understand, which is what we just went over. Okay, a financing statement. Security interest for most types of collateral are usually perfected by filing a document known simply as a financing statement. That's the UCC we talking about, y'all. The purpose of the financing statement, which is filed with the public office, such as the Secretary of State, is to put other people on notice of the secured party's security interest in the collateral. The UCC specifies that what must be contained in the financing statement: the name of the debtor, the name of the secured party, and the indication of the collateral. Okay. Regarding the first of these items, it is important that the name of the debtor be sufficiently sufficiently specific and accurate, because financing statements are filed under the debtor's name. Okay. If the name on the statement is wrong, the statement will fail to provide adequate notice to others, and others will not succeed in perfecting. Others will not succeed in perfecting the security interest. I think that speaks for itself. Section 9-503 of the UCC provides various more specific rules regarding the sufficiency of the debtor's name on the financing statement. For example, the debtor is a registered organization, which might mean a corporation or LLC, limited liability company, organized under a particular state's law. When the name on the financing statement must match the name of the must match. I'm thinking while I'm talking, y'all. Then the name on the financing statement must match the name of the debtor as the registered with the state. The second required item on the statement, the name of the secured party, is generally a straightforward matter. Finally, as to the third item, the rules for indication of the collateral on the financing statement are largely the same as the description of the collateral on the financing on the security agreement. See above. However, unlike with the security agreement, the financing statement is acceptable to use a super generic description of the collateral. Okay, I think I'm gonna pause right there, y'all, because I can actually read this whole thing right here, but I don't want to actually lose. I don't know if I want to read the whole thing. Well, I might as well. Shit, I done read most of it. I think I done read most of it. Where did I stop at? I should have damn just kept on going. I think I'm starting at the standard form. I'm going to just read the whole damn thing. Fuck it. Anyway, a standard form known as a UCC-1 is widely used by secure parties to file a financing statement. You can easily find a sample UCC-1 online. While many financing statements must be filed with the Secretary of State, you should check your own state's laws for more information. As a final point, be aware that the financing statement can be and sometimes is filed before the security interest is attached. Creditors do this in anticipation of creating a security interest in order to make sure that the interest is perfected immediately upon attachment. Okay, possession. A security interest in many types of collateral, including negotiable documents, goods, instruments, money, or tangible chattel paper, may be perfected by the secured party possessing the collateral. However, so-called intangible collateral, such as accounts receivable, cannot be perfected by possession. While possession is not directly defined by the UCC in this context, it does appear to include possession not only by the secured party, but also by the agent of the secured party. Okay. I'm gonna read this part. I think I got one more part after this here. Control. The UCC states that security interest in the investment property, deposit accounts, letter of credit rights, or electronic chattel paper may be perfected by control of the collateral. Say the mean of control can vary depending on which type of collateral is involved. For example, a secured party may have control of a deposit account if the bank, the debtor, say the debtor and the secured party have all agreed that the secured party may handle the funds in that account without further consent by the debtor. I've actually got a trust account, y'all. I got a trust account with my trust. So you can actually, once you execute your trust, you can get a certificate of trust. It's called a certificate of trust. In most states, if you type in certificate of trust followed by your state, the state that you're in. They have a code as to what needs to be in your certificate of trust, and you get that thing, typed up according to your state requirements, and you can actually take that to the bank, whichever bank you choose. Some people, I'm not gonna go into which banks to go to and which ones you can't go to. You'll find out, as you go through and find out or whatever. I went to Truist myself. Some people tell you don't go to Navy Federal, but I know some people that's going to Navy Federal. So I don't know what banks or that won't. I don't know if any banks that just really give a hard time, because I haven't had a bad experience. But you can take a certificate of trust to the bank with your ID, and you can actually open up a trust account using your EIN number. The name of your trust. Your certificate of trust has the name of your trustee in it anyway. It has the name of the trustee and all that good stuff. You take your certificate of trust with your ID. I would prefer the passport if you have a passport. If you don't have a passport and you got a driver's license, then do that. But y'all go look at my video concerning what's supposed to be used as an identification card, and you'll learn what's supposed to be used for identification, and you'll learn that a driver's license was never intended to be used as identification. So that's another topic for another video too. But just go back and just look at my previous videos, you'll see that. But I would use my passport. Okay, passport. If you have an ID card, use your ID card. But those are the only two things that's supposed to be used for identification. But anyway, go there with your ID, the proper ID, and your certificate of trust, and you can open up your trust account. Okay, and that's what you're gonna be. You're gonna be using to open up a trust account if you choose to do so. I would definitely advise you to do so. And I'm gonna show y'all a little nugget real quick when I'm done with this here. So y'all keep watching this at the end. Okay, I wasn't gonna put this on the internet, but I'm gonna put it on the any damn way. I think I've done it before. Shit, fuck it. Anyway, automatically upon attachment, the most important type of security interest that is perfected immediately upon attachment is what is known as a purchase money security interest, PMSI, in consumer goods. A PMSI generally involves either one, the debtor buying an item or credit. This is something we ain't talking about. We ain't talking about that right now. I don't want to throw y'all off. Final note. This article is based on the current version of the model UCC, Uniform Commercial Code. However, not all states have adopted all sections of the current model UCC. Moreover, the model UCC specifically leaves it to the individual state to determine the precise wording of certain sections. Therefore, you should always check your own state's commercial codes for most accurate information. Now, keep in mind, this was from back in May 2013, but y'all do your research on this stuff. That way you can confirm what it is that your state is saying. But I'm gonna show y'all this nugget. The reason why I went and got my certificate of trust, I went and did that because I'm gonna show y'all something real quick. Okay, right here, 31 CFR subsection 363.6. Okay, look at this. They treat y'all like, show y'all something here. Check this out. A lot of y'all don't know your position in these courts when you're dealing with court. I don't know why I scrolled out so damn fast. These terms are in my alphabetical order, okay? Minor. They think you all are a minor, okay? Check this out. A minor means an individual under the age of 18 years. That's what y'all always thought, but keep on reading. The term minor is also used to refer to an individual who has attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. Look at what a minor account is. A minor account means an account that a custodian controls on behalf of a minor that is linked to the custodian's primary account. Click on Cloud Primary Account. Bam. Here we go. Primary account. A primary account means the account that you establish when you first open your Treasury Direct account. Your primary account is the portal used to open and access all your linked accounts. Okay? CC See 363.10 for more information about a primary account. Now, I have never done this before, but I'm going to do this here. I'm going to do it this time just because I'm recording. Okay, what is a Treasury Direct account? What is a Treasury Direct account? A Treasury Direct account is an online account maintained by us solely in your name. Whose name? In which you may hold and conduct transaction in eligible book entry Treasury securities. So that's what you want to be doing. This is one of the reasons why I opened up my account. I opened up me a Treasury Direct account with my trust account. Okay. So until you got to be able to you need to be taking control of those damn securities. There's a lot of securities in your name. Okay, it's a lot of them, a whole bunch of them of them. There are securities in your every court case. You got a court case, your bills, your light bills, any damn thing. They create securities for every damn thing with your name on it. But I'm a beginner when it comes to this stuff. I'm learning as I go too. But I've already gotten this far. I've done this already. Okay, so you can go online and open up your own account. Of course, they had to take a couple months to verify my identity and all that good stuff. So I did that, and now they have verified it. It's called a 5444 form. It's a Treasury Direct form. They had me to fill it out, and I filled it out, sent it to them. Well, I had to go to back to the bank that I went to, and had one of those big wigs to actually do a signature stamp or whatever. Basically verify my signature and my identity and all that good stuff. And now I have full access to my account. So they will not be able to try to call me, try to see me as a minor anytime I go to court, because I'm definitely going to be anyway, I just want to share that little nugget. That's why they see y'all as a minor also. If you can be well after 18, but if you don't have control of your minor account, you saw it for yourself, they still see you as a minor because you don't have control of your minor account. Okay, you need to do that. And I think the best way, it's just my opinion, the best way to do it is with a trust, because a trust is private, and a trust is a trust is an entity that you created and the state did not create. And you have security interest in that, in the Cessna KV trust, which means you're able to control it. Once you reach the age of 18, you're supposed to take control of it. And once you take control of it, now you can move it into your own trust that you create. It takes it out of their jurisdiction, so they can't just shit on your rights like they've been doing all your goddamn life. So anyway, I don't want to get into a tangent, because this video, I ain't never did a damn video this goddamn long. But y'all might want to look at it's another, what's her name? Tamara Bush. I forgot her middle initial. Tamara Bush. She has a YouTube channel on here that goes all the way through that Cessna KV Act. And she also goes to this same NOLO, that same website that I was just showing y'all. And she actually went in greater details than even I did. So she breaks it down. She is phenomenal. So y'all shout out to Tamara Bush. I've never even spoken to this woman before, but I'm a subscriber to her channel, and I learn shit from her too as well. I'm a new subscriber actually, but I've been studying this shit for like 8 years now. But she actually goes through the consumer laws and went about credit and all that stuff too. I hadn't got into the credit part of it yet, but I'm on my motherfucking way. But anyway, y'all, I think I've gone farther enough. I'm feeling good. I think I still need to lay my ass down and rest, because it's 1-something in the morning, and I got stuff to do first thing tomorrow. So I think I dropped enough jewels for tonight. So we'll have to catch up with y'all on the next video. If you haven't subscribed yet, please subscribe. Share these videos. Okay, put me on out there, y'all. I'm trying to share as much as I can now. I got big plans, and I'm trying to do some big things. All right, y'all. Love y'all. Y'all already know that. I've been doing this shit for years, helping a lot of y'all out now. Helping y'all, dropping out what I can as I can. Okay. So y'all hold it down, y'all. I'll see y'all in the next video. EmRôs signing out.